SJC-12494, Commonwealth v. Terry Lynn Owens.
Good afternoon again, Your Honors. I am here representing Terry Lynn Owens, the defendant appellee. Mr. Owens was successful on his motion to suppress in the trial court. In the appeals court agreed with Mr. Owens that he had standing, that he had a reasonable expectation of privacy, and that the protective sweep was not justified. If this court agrees with those rulings, I will move on to the area of disagreement, which is whether there was an exigency at the time of the search of the second floor that would have made that search legal. The defendant...
Search or sweep?
Well, it was a sweep. However, the sweep required going into 5 individual rooms. The only room we know about is the second room where Mr. Owens was located. The officer went to the door, opened the door, and entered. So although it can be categorized as a sweep of the second floor, it was also, in essence, a search for persons located on the second floor that required opening doors and going into rooms where the police believed people were present. The arguments are twofold. The first argument is that because there were no specific facts creating a reasonable belief that there was evidence and that the evidence might be destroyed, that there was no basis to do the sweep in advance of getting the warrant. The second argument is even if the court holds that a sweep in these circumstances are allowed, absent specific facts, it should not be allowed in this case because police intentionally put themselves in a foreseeable situation where they would have to conduct a protective sweep when it was unnecessary. The court does find, the appeals court does find that prior to undertaking the sting operation, the police did have probable cause and could secure a warrant. An exigency requires that it be impractical for the police to obtain a warrant before undertaking an action such as a sweep or a search. In this case, it was not impractical for the police to obtain a warrant because the appeals court specifically found that prior to creating the exigency by doing the sting, they did have probable cause and could have secured a warrant. So those are essentially the two pieces.
What was the information with regard to condoms? I know that there was some uncertainty as to what the judge found and as to what the evidence was.
Well, the judge found that there was insufficient evidence introduced at the hearing about Mr. Ahmed, the owner of the house, supplying drugs and alcohol either to patrons or to the women who worked there. However, he did find that there was sufficient evidence to draw a conclusion that this was a brothel and that in the process of running this brothel, Mr. Ahmed would provide condoms to his workers that they could use in their trade. That was a finding that the trial court did make. However, he did not make any findings regarding drugs and alcohol. So any search or sweep to find drugs, the court found, would not have been permitted.
But Ms. Campbell, in a moment, since I know her so well, and since she's argued it in her brief, is going to say that that's sufficient, that the fear that the condoms will be flushed down the toilet was sufficient to permit a sweep.
Well, the facts require specific evidence that these items will be destroyed and that they're evidence of a crime. The condoms are not contraband. The presence of a condom or condoms inside of a house does not necessarily provide an inextricable link to criminality. In essence, the appeals court decision says that simply because they were in the house, they could hear people upstairs. That warranted them going upstairs, doing a sweep, locating all of the people inside of the house, bringing the people outside and securing it until a warrant was issued.
I'm sorry, is that what you're saying they should have done? What should they have done?
What should the police have done? Well, the police had some options in this case. The first option was knowing that they were going into this residence, knowing that they were going to undertake a sting involving Cinnamon and Mr. Ahmed, knowing that the end goal was to be in the common area on the first floor with Mr. Ahmed and Cinnamon under arrest, knowing prior to that that this was a house of ill repute, that they had spoken to several prostitutes, they'd spoken to a customer the prior day, knowing that they were going to have to enter the house, that they were going to have to search the house. They could have just gotten a warrant, done the sting, they would have warrant in hand, there'd be no exigency that they created, and they make the arrest in the common area, they have a warrant, and they go at it.
There was enough information for them to have gotten a warrant before they went in?
Yes, Your Honor, the appeals court specifically finds that although the police had probable cause to believe that the place was a house of prostitution, due to the testimony of the neighbors, interviews with known sex workers, and their interview with a John who was found leaving the location, they did have the ability prior to undertaking the sting. They could have gotten a warrant and had a warrant at the ready when they knew inevitably they were going to have to enter this house to conduct the protective sweep.
And the arrests occurred where?
In the common hallway of the front floor of the house. After the officer who was acting as the John signaled to other officers, an unknown number of officers entered the common area of the first floor and effectuated the arrests of Mr. Ahmed and Cinnamon. And it is not in the record, but it can be inferred that they were then removed from the house and brought to a cruiser and processed in the ordinary course.
Okay.
If there are no other questions, I would rest on the brief.
Thank you.
Thank you.
Ms. Campbell.
Good afternoon, and may it please the court, Kaylin Campbell on behalf of the Commonwealth. We ask you today to reverse the allowance of the defendant's motion to suppress, affirming the appeals court decision. And I'll start with a factual question as to what was the evidence about contraband that was inside, or not contraband, but condoms that were inside the house. It's on my record appendix, page 14. It's the judge's finding that there is specific testimony that Mr. Ahmed would provide drugs, alcohol, and condoms for sale. So he was selling those things within the house. I'd say, though, that the condoms are indicia of prostitution, which is what the sting operation was about. So at the very least...
Sorry, indicia of or evidence of?
I think it's evidence of. I think that there's a reasonable inference that in any... My brother kept on referring throughout his argument as to this structure as a house, and I think the evidence at the motion to suppress hearing established that it was not a house, it's a brothel, and I think that changes the analysis of what you can believe would be inside that structure. It would include indicia of prostitution, including, as the judge specifically found, condoms.
I mean, as I recall, the judge said there was evidence solicited with regard to drugs, condoms, and something else, and I don't find any evidence with regard to drugs and something else. But
The drugs and alcohol.
Did not affirmatively say, you're saying that the omission of it from that sentence indicates that the judge accepted the evidence with regard to condoms?
Yes.
But am I correct, there was no finding that condoms were likely to be found? It was just him referring to the fact that there was evidence of that and him not rejecting that?
He said there was testimony that Ahmed had supplies of alcohol, condoms, and drugs for sale. There was no testimony, and this is on record appendix page 14, as to the basis of knowledge of the officers as to the drugs and alcohol. So I would say that you could read that and find where the judge does make explicit factual findings and credibility determinations about some of the testimony and not others, that it's reasonable to infer that there is enough to... Was
there testimony that they saw condoms when they went in?
When the officers originally went into the...
Yeah, what's the evidence as to condoms? Because I mean, that's, in terms of the requirement of specific information supporting an objectively reasonable belief that evidence will indeed be removed or destroyed, I gather you're focusing on the condoms.
I am focusing on the condoms. I wonder, though, when we're talking, and I think this is where there really isn't any guidance in the case law currently as to As to that question that you're asking, what is the quantum of evidence that there needs to be about the evidence that the police will find? Because typically what you have is you have an instance, for example, in a lot of the cases, take a case like Streeter, for example, where they're going to an apartment because there has been probable cause to believe that there's drug dealing. Obviously, what they believe inside the house will be evidence of drug dealing. I'm not sure that there is anything in the case law, at least that I could find, that talks about the fact that the police have to have probable cause to believe that that the evidence will definitely be there, or that the evidence will definitely be destroyed. I'd say to the extent that there is a requirement that the police have probable cause to believe both, and that would bring us into the probable cause plus exigent circumstance sort of category of searches, and there would be no need to get a search warrant.
Are you saying it's enough if they say it's a brothel, there must be a condom in here?
I think here, I don't know if I want to go that far. I think here where you have testimony that there are condoms for sale and that it is a brothel, then yes. I think
Was that, I mean, the issue, I guess, the judge found no personal knowledge. I'm just trying to find what the
well, he found no
basis was, as to the drugs and the alcohol. I know, I'm trying to find out what the,
Sure.
whether or not even the evidence would support a finding with regard to condoms, where the judge affirmatively made it only by implication.
Sure, and I'm happy, I have the transcript here. I'm happy to provide it in a 16L letter. I can't speak to whether I specifically cite that in my brief. But I would say it should be enough where you have probable cause to believe that the individuals in the house, there are both individuals there and they're engaged in prostitution, that there is evidence of that prostitution in the brothel.
Which means anytime you do that, you can do a sweep of a brothel?
No. I say you have...
Isn't that what you're saying we should find? Because if it's a brothel, there must be evidence there's likely to be some evidence of the prostitution there?
I think there's a reasonable basis to believe there will be evidence of prostitution, but you can't do the sweep, at least a securing of the premises inside the premises, unless you're validly within the structure and unless you have an objective basis to believe that there are people inside of it, which we have here.
Okay, but you're not arguing that they were in danger and needed to do the sweep in order to protect themselves, are you?
No.
Oh, so that's gone from the case.
Correct. I made that argument below to see how far I could push it, and because I didn't want to waive it. It's the true story, but no, I'm not going to press that here before you.
The issue is not danger, which of course we respect. The issue is condoms, basically.
Well, the issue is what officers are supposed to do when they're validly within any kind of structure. Here it's a brothel, and they have an objective basis to believe that their crime scene, which it is not secure because there are people inside.
So it's basically what inherent evidence of that crime could be about. If it was a drug den,
It's
for
drugs.
instance, they could search to see other drugs or drug paraphernalia, crack pipes, etc.
Correct.
And here, because it's a brothel, you think they can look to see, and actually there's a footnote by Justice Kafka about sex toys and condoms and such.
Correct. And I don't think that the case law requires more, because
Wait, doesn't the case law require a specific information supporting an objectively reasonable belief that evidence will indeed be removed or destroyed unless preventative measures are taken? I'm getting that from DeJesus.
And so DeJesus does say that, but it says we need not determine with precision the minimum requirements which would justify that. And
What are the minimum requirements? I mean, what do we have here to show?
Sure. Here you have the crime itself, you have the finding that there are condoms for sale, and you have the objective information that there are people inside, both a known prostitute and an individual who have walked into the home immediately before the officers, and the hearing of the noises upstairs, which it's reasonable to infer we're talking about probable cause to believe that those upstairs rooms are being used for sexual activities.
But how do you make the leap that there's evidence or some indication that they're going to destroy evidence?
And I think that gets to the quantum of proof analysis, what you are essentially, how much and what is sufficient for the Commonwealth to prove. I think in this instance where you have what could be indicia of prostitution, which could be easily destroyed, something such as a condom, then that would be sufficient. But you also have individuals that are engaged in criminal conduct in the home or in the structure. So I think that changes it from the type of analysis where you walk into someone's apartment, you don't necessarily know in someone's apartment, it's less reasonable to infer that they're going to A, have evidence of a crime, or B, be destroying evidence of that crime.
It has to be more than a guess.
It has to be more than a guess. I agree, but it also has to be less than probable cause, because if you had probable cause, then you could just do a full search because of probable cause and exigency.
Totally common sense. Is it reasonable?
Yeah, yes. Yes, and I think you have to have an objective, that's where that objective standard comes in, the objective basis to believe. And can you point to facts and reasonable inferences from those facts in a record to support why the officers had this belief?
Going back to Justice Budd's point, it also says specific information. So are you saying we should not require specificity, or that we should maintain that standard?
I think you could maintain that standard with an explanation as to what that specificity means.
And what do you say it means?
I think it means what I tried to just articulate in response to Justice Lowy's question, which is looking at the facts and the reasonable inference from those facts, that there is an objective basis to believe that there are people inside and that there's evidence related to the crime that could be destroyed.
Okay, one last question, which doesn't relate specifically to the merits of this appeal, but you arrested Cinnamon, too.
We did arrest Cinnamon.
I thought we view prostitutes as victims, not as criminals these days.
I can't tell you what happened to Cinnamon's case. I can't tell you, it says that she was arrested, whether a criminal complaint was actually taken out, I don't know. This defendant isn't related to that prostitution
I
part.
understand, but I know that we speak of it as human trafficking and generally do not view them as criminals, but as victims, so that's what caught my eye.
Correct, correct, but I can't speak to what eventually happened to Cinnamon. If there are no further questions, the Commonwealth will rest on its brief.
All right, thank you.